I want to thank Sarah, Daniel, and Larissa, and Jolie for setting this up with you all, and tell you just a little bit about Vancouver Birth Injury, and then I think Rich is going to have some of the answers to any legal questions you'll have. It's really a group effort. It's not so much just mine as I researched it and got kind of things going, but I was talking with Colette, Parsons, and Harris, who are the lawyers here in Vancouver, British Columbia, that are doing all the legal work. My team or my firm is in the States, so all the work we perform is in the States, nothing up here at this point, but through obviously modern technology and emails and things like that, we're able to work together on these cases. And our real focus here is to help people who have children that have suffered from a birth injury, preventable birth injury. We really try to help identify who's accountable in situations like this and identify what went wrong. My background really is as a physician. I started as a physician, went to medical school, and then after beginning part of a residency in surgery, began training as a lawyer. Worked with Jerry Spence, who's the guy to my left right there. Some people say he's the best trial lawyer to have ever lived. He's never lost a criminal case and hasn't lost a civil case since 1969. He was a great guy to learn from. And then I started working with another lawyer who does a lot of medical malpractice work and did a few birth injury type cases. So I became interested in that, and because of my background, those cases naturally went to me. And so then I went on and got some specialized training through Harvard Medical School in obstetrics to help me better understand how these cases work. And I started working with lawyers throughout the United States on these cases and expert witnesses throughout the United States. And in particular, a lot of experts on the West Coast, UCLA, UCSF, San Francisco, and some in Seattle as well. And then I ended up having one actual case where the physician had relocated to Vancouver. It was a pediatric surgeon, and it was a birth injury related to the surgery right after birth, and which brought me up to this area. And in researching this area, I found that it seemed to be underserved. While there's some good firms here that do birth injury, not a lot really. And in researching the area, I found that Rich and his firm were really an up-and-coming law firm, young, aggressive, very successful, and certainly one of the best, if not the best, in the area. So I approached Rich and his partner Guy about maybe working together, some kind of effort like this. And so we've taken off with this idea of Vancouver Birth Injury. And I'm in the process right now of getting my permit to practice foreign jurisdiction law here. And after that, we'll get into getting articles where I can actually work with them on more closely on the actual legal aspects of the case and not just be working in the States. I guess maybe to kind of show a little bit about the work we do and why it's important to have somebody that has the medical background. This is an example of a fetal heart tracing, and I won't get into all the details, but just to show that this represents a tracing that where if the doctor would have intervened right away, the baby could have been prevented from having some kind of severe catastrophic brain injury. Because what happens, you can see that heart rate is way up above 180, and there's not much movement in the lines. It's almost a flat line, or it's very smooth, and that indicates always that there's lack of oxygen to the baby. And if you go to the next slide, you can see this tracing. Now you've got the squiggly marks. It kind of bounces around a little bit more. That's an indication that the baby's doing pretty well. But again, these are sometimes complex things to read, and I can help by, when the medical records are sent to me, I can help look at these and the other medical aspects of it. Then Rich and his team, his lawyers up here, can move forward with the case when we find that there is one. Also, they have experts they work with that know from their practice, but I have a lot of these states that I work with as well. If you go to the next tracing, you can see how the squiggly marks there on the left, how it goes to that kind of more of a flat line. And so that's another indication. Here's a case again where the baby has suffered lack of oxygen. And this type of, you can see that there's a deceleration right there. And there's this bottom is the contractions. It shows the mom, and there's a contraction. And you notice this deceleration doesn't start until well into the contraction. That's called a late deceleration. And again, that along with the flat line indicates this baby was in deep trouble. In this case, actually, the baby was severely brain damaged. And each one of these dark lines represents 1 minute. So you know problems are developing there. It's confirmed several minutes into it. Somebody sees it, they're making marks on the tracing. But yet, you've got, if you count these out, I think it's going on close to 20 minutes, and they still haven't even tried to intervene at this point. So our job really is to try to find out if something was done wrong, it was preventable, and then we look at what are the aftercare needs, which often and Rich can address this better, what the state will pay, the government, the insurance will pay, and frequently it's not nearly enough to really care for these children in the homes, where most families want to keep their child in the home, child with cerebral palsy. We try to look into that, and that's one of the things we do. And I guess the other thing just to mention is this is the whole area of not only Vancouver but British Columbia, the Rich's firm services. So we're interested in helping any families throughout British Columbia. And then as far as the legal aspects of it, there are some things about time limits and which are important to know, and also recoveries that Rich maybe you want to address some of the legal aspects of these things. That'd be great.
Yeah, so we met Brad about 1.5 years ago, and we're really excited to meet him. It's great to be able to work with a doctor and lawyer on these types of cases. We do a lot of tort work, we do some medical negligence work, and we know from the research that the vast majority of medical negligence goes unreported. Families don't even know oftentimes that they have rights that they may not be seeking any remedy for, and the expense to families and to our society is massive when doctors make mistakes that cause a lot of care needs going forward. Lots of these kids that have brain injuries will require 24-hour care or significant amounts of care, and it just ends up falling on friends and family members or the limited social services that are available. The limitation period for bringing these types of claims on to try to get some kind of help for these kids is 2 years from their 19th birthday. So they've got 21 years within which to bring on a claim. So we're really excited to be working with Brad and try to, when you do these kinds of cases, you can make a real difference in the lives of families. It's a very rewarding thing, and we know from the research that there's a lot of these types of cases out there where people don't even know their rights, and they don't even know that there's remedies out there for them to go after. So we're really fortunate to be working with Brad and excited to move forward on some of these cases. And with the medical expertise, it allows, oftentimes these cases are very complicated. If you start an action on somebody's behalf, you've got to get in all the medical records, you've got to go and analyze everything and figure out whether there was a preventable error. And that can take a lot of time, and it can be very, very expensive and cost prohibitive to a lot of these families. But when you're working with a doctor who knows the medicine, who can review the charts and review what's going on, we can provide advice on the medical side quickly to people and let them know whether we think there's a case that we can help them with. So, really appreciate y'all taking your time today to come see us.
I have a question. Are we on to questions now?
Sure.
Awesome. Yeah, we'll move on to questions now.
So how does it work? Like, is in Canada, you can't sue the doctor personally, can you? Or are you suing the hospital, or how does that work?
You do sue the doctor and the hospital, depending on whether the procedures. You sue the doctor if we suspect that there was negligence, we make a claim against the doctor. And if we expect the hospital's procedures were inadequate, we make a claim against the hospital. Then we get production of all the documentation, and we get to review that. That's the stage where we go through everything with Brad, and then we can conduct what are called examinations for discovery, where we get to sit down and ask the questions about what's in the record to see if there was a preventable mistake. And what people don't realize in Canada, because we have socialized medicine, they think that there's that people don't have these rights, but the only recourse people have is that process. The only way for them to, our system is based on the assumption that if there's a problem that something shouldn't have happened, that people are going to obtain their rights through this process. So what's available through the socialized system is really very limited. So it either ends up with a family member, a mother or a father, who can't work because they've got to take care of the sick child, or they just live in a really substandard way and don't have much quality of life.
And who pays for this discovery process and initial investigation?
Well, there's not a lot of expense up front because it's literally filing the documents, and then we're entitled to discovery of the documentation. And then it's our time in terms of reviewing the information. but we don't charge anything to investigate a case for people. And then all the cases that we do on pure contingency basis. So if there is a legal fee, it's only a percentage of what's recovered. It's never, we never ever render a bill to a client unless we've achieved a result for them.
So what happens if the parents had decided to take the child off of life support and the child passes away? Is there different guidelines? Like obviously they're not going to file a claim 19 years later because the child's no longer
There is,
around,
and there's,
right?
unfortunately, British Columbia has something called the Family Compensation Act,
Yeah.
which says that there's very, very limited claims when somebody dies.
Okay.
Basically, the only if I were killed tomorrow due to somebody's negligence, my kids would have a claim because they're my dependents.
Right.
So what the act says is you basically look at like what I would earn over the course of my life, less what I would consume myself, and then my dependents are entitled to that. But a baby, of course, has no
Yeah.
dependents. So literally, children that die are like valueless in the eyes of the law.
Okay. So they wouldn't have a claim then if they took the child off life support and decided
No.
no.
And the issue here is for kids that survive and have needs, and trying to, what the law says, if they're entitled to be returned to the full extent that the law can, if there's medically justified care that's required, the kids should have that care to try to give them the fullest quality of life possible, depending on whatever the health complication is.
The only thing that I can see a problem with that is that the child was healthy till delivery, and then something went wrong during the delivery, and the child became brain dead, obviously, and brain damaged. And so they made the conscious decision not to continue and just to, let her go, right?
Sorry?
They made the parents decided to let her go, so they took her off life support. But she was perfectly healthy.
Oh, I don't know about the medical decisions in that regard in the hospital,
Yeah.
but I think that if the child's perfectly healthy, nobody can decide to take them off life support. But
No, what I was saying is during her whole pregnancy, she was perfectly healthy. When it came to the
Oh.
labor and the birth, that's where complications came in. So they think something happened. Either the doctors didn't do what they should have, or the
Well,
hospital.
maybe Brad can feel that because with the Canadian law aspect, but in terms of the medical side of things, Brad.
Sure, and I can draw an analogy at least to the States. We do allow recovery in the States
Yeah.
when the child passes away, and like what Rich is telling you here. But we have the same law in workers' compensation. If someone, even an adult, if they die in a work-related injury, and it's strictly a workers' compensation case, if they have no dependents, then like the mother, the brother, the sister, nobody can make any claim because it just in the law, in the eyes of the law, as Rich said, they just have no value. It's sad to say that. And the same, I think, if I'm hearing what Rich is saying right, that's the same thing. Unfortunately, just like this, if you can go back a slide or two, Catherine, you can see that tracing, and that's almost exactly what the client had right there. You have this baby that was probably doing okay, it was normal, and then something happened right in here. And they ruptured the membrane. That's AROM stands for artificial rupture membranes. And so what happened is all the fluid goes out. And an example, I'm not saying it happened in this case, but an example would be a cord around the neck. Maybe because of the amniotic fluid, the cord's not too tight, it's not getting compressed, but this fluid goes out and this cord gets taut. And now there's no blood flow. And so all of a sudden there's no blood flow, there's no oxygen, and you get a low perfusion, a low oxygen level. And so all this starts happening, and this baby has severe brain damage. If the baby lives and needs care, then Rich's firm can come in and help out. But if the baby does not survive, it sounds like there's nothing that can be done.
It's tragic, but and the Trial Lawyers Association of British Columbia, I was president last year, and we've had a campaign on changes to the Wrongful Death Act in British Columbia that's been ongoing for a decade. So we're trying to put some pressure on getting some change in that regard, but it's
So unless you're older, obviously you have some value. I don't want to say that the baby didn't have any value, but that's essentially what you're saying.
in the eyes of the law.
Yeah.
The only exception to it is in some cultures where they have a concept called filial piety, where there's a sort of a social contract that the parents will take care of the kids, and the kids take care of the parents. There can be claims, but not really for birth. There's got to be some evidence that the kids sort of have adopted that belief system. We're going to do it.
Right.
So if the child lives, is there pain and suffering amounts that get awarded to parents, or is it only to like the child's loss of enjoyment of life?
The entire claim is the child's claim.
Okay.
And in Canada, the pain and suffering damages are limited to $100,1978, which is about $350,000 today. So someone's got a quadriplegic or a severe brain injury, total functional loss, or a child like this, that's the maximum for pain and suffering. But there is no maximum for any care that's required, and there's no maximum for income loss depending on the age of the injured person. Of course, here we're talking about kids. But the only claim that the parents would have is the parents can make what's called an in-trust claim, and they can claim in trust for the value of the services that they provided for the child up until the time of the trial. So say a trial it could be 23 years after the child was born, and if the parents have been, maybe they didn't know they had these rights and they've been doing all the care for 20 years, they can actually claim for what they would provide above what a parent would normally provide as part of what's called an in-trust claim.